everyone. Today I'm making this video about the procedure as stated in Moroccan labor law that should be followed in case an employee committed serious misconduct, allowing the employer to terminate his employment contract. Here it's really important to note that if this procedure is not followed, as I will explain in this video, then the termination of the employment will be considered as abusive, giving the employee the right of the severance package. So now there are two cases. Case number one is when the employee commits a serious misconduct, a serious fault, and the employer follows the procedure as stated in the Moroccan labor law. In this case, the employee will be laid off legally with no indemnity, with no severance package, with nothing. Case number two is when the employee commits a serious misconduct, a serious fault, and the employer does not follow the legal procedure. Then in this case, the employee will be entitled to the severance package because the termination was not done properly and it was abusive. First of all, what is serious misconduct under the Moroccan law? So under the Moroccan law, as you can see here, we have Article 39 that lists examples of serious misconducts that could be committed by an employee during his employment. So you can see here we have a list of 16 examples. This list is important to note that it's not exhaustive, but it's just here to give you an idea of what's considered a serious misconduct. So what's the procedure? Okay, first of all, is the first step is for the employer to summon and to call the employee who he wish to separate from in order to hear them in a context of a hearing or a meeting. So the first thing is to hold a meeting with the employer who committed the act. So once the employer discovers an act that could justify termination and wishes to proceed in this direction, he has 8 days. So important, this deadline. So once you are an employer, you discover your employee committed a serious misconduct, you have 8 days to have this meeting with him, this hearing. So any measure taken after an interview that is organized beyond this deadline would be considered abusive. So important. So you had definitely to have the meeting with him within 8 days. That's the deadline. However, before holding the meeting, before having the meeting with the employee, it's important that the employer needs to invite the employee formally by a letter. And it's so important to send it via post or any other way that can justify the reception of the notice by the employee. In this letter, the employer must mention the reasons or grounds for the meeting, the time, the date, and the location of the employee's hearing. Then the physical meeting, the hearing, must take place on the company's premises, which is what's normal, like in the office. Now, who can attend the hearing? So among the people who can attend the hearing, of course, it is the employee, the employer, or his representative, a delegate of the personal or union representative. And what's going to happen during the hearing is that the employer will ask questions and explain why we're having this hearing and explain why this is a serious misconduct, what's the acts that was committed by the employer was how it affected the company. And then the employer must hear the employee. This is why we have this hearing, to hear both parties. At the end of the hearing, a minute is drawn up and signed by both parties. The labor inspection is resorted to if one of the parties refuses to continue the termination procedure. Also, it's important to have a bailiff waiting in the company in case the employee refuses to sign the minutes of the hearing. Then the bailiff can then issue a statement where it's mentioned that the employee did attend the hearing, but he refused to sign the minutes. It's so important to have a formal minutes or a notice, with a letter where it said that we had this meeting and this was said in this meeting, and in the end you have the signature of the employee or in the employer or his representative. So in case the employee refused to sign, you have the bailiff in the company, not with you in the hearing, but just in the company premise, where just in case the employee refused to sign, then he can issue a formal letter where he says the employee did attend, but he refused to sign. So if you're an employer and you have decided to terminate the employment contract of this employee due to the serious fault, misconduct committed by the employee, then after the hearing, after a few days, you will have to send a termination letter to the employee by the bailiff, which can give you a formal notice of the reception of the letter by the employee, because it's so important to be able to justify that the notice was received by the employee in case this goes to court. In the termination letter, you will have to mention that you had the hearing session on this date, and that after some thoughts, it was clear that the act is serious and cannot allow the continuity of working relationship between the employee and employer. Also, in the notice, it's so important to mention that the employee have the ability to it's a legal right to sue within a 90 days deadline of the reception of the termination notice. He has the right. And also it's important to mention this in the termination notice that will be given to the employee. I just want to mention that I have already written an article in my website, africalaws.org, about this topic, and I have mentioned the procedure with everything, with the steps to be followed. So if you want to check it out, this is my website. You can see here I have already published the article with all the steps. In my website, you can find articles about African laws updates, and if you're interested, you can check it out. I'm gonna leave the link for the website and as well as the link for the article regarding the employment termination. Thank you. Lastly, it's important to notify the labor inspection of all these steps by a notice. So when you have the meeting with the employee, you have to notify the labor inspection, and you have to send him the minutes of the hearing. Also, the termination letter should be also sent to the inspector. And at the end, there is two options. Either the employee will sue the company, and then this is when all this comes to play. So if the employee sue the company and the company did follow the procedure legally by having the meeting, having the minutes of the meeting sent to the inspector, having also the termination notice, observing the deadline of 8 days, observing all the deadlines, having all the documentation, and then there is a high chance that the company will win the lawsuit. But in the other hand, let's say the company did not observe the deadline of 8 days, or did not have the termination notice sent to the employee, or missed any of the steps that I have listed, then the termination will be considered as abusive, giving the employee the right to have all the indemnity and service package. So we are at the end of the video. Thank you everyone for watching. Don't forget to leave your question in the comment section. If you have anything that you're curious about, you want to understand in the Moroccan law, you can ask me and I will make either a video or answer you directly. Thank you so much for watching and have a good day. Bye.